Greetings and welcome to Trust Explained, Principles, Pitfalls, and Practical Applications. This is a compilation of many of the live streams I've done. I've done probably more than a half a dozen of them on trust alone from American jurisprudence, common law trust, and what I seem to get is just to have it all explained in more practical terms, and that's what we're going to do tonight with this presentation I've compiled from the best of information I've accumulated so far. With that said, please hit the like if you just get in here so we can get the word out and notifications, which seem kind of thin for such an important topic. But that said, let's begin. So, Trust Explained, Principles, Pitfalls, and Practical Applications. Before we go any further, just to remind everyone, this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, misconstrued, or misused for anything legal, private, personal, business, tax, financial, lawful, or otherwise. So please don't do this at home. That said, let's get started. So first, let's look at the types of trusts there are. Trusts aren't all alike. There are law and practice recognize a range of distinct forms, and each of them are suited to different goals. Some arise from the settler's clear intent, while others are imposed by courts to remedy wrongdoing. Together, these types show the flexibility of trust law. So let's look at some of these trust types. There's the express trust, which is created intentionally by the settler through a declaration or instrument thus expressed. There is the testamentary trust, established through a will, effective only at death. There's the resulting trust. It arises when property is transferred in circumstances suggesting the recipient was not meant to keep it outright. And then there's business trust, also called a Massachusetts trust. It's an enterprise trust where trustees manage property for profit, with beneficiaries holding transferable shares. We'll get into all these details and terms. There's a living inter vivos trust, an express trust, another type of declaration through a declaration or instrument, an intentional trust created and funded during the settler's lifetime. There's the constructive trust. That's imposed by courts to prevent unjust enrichment when property is wrongfully held. There's a charitable trust, which are dedicated to a public purpose, such as education or relief, enforceable by public officials. That's an interesting concept there. And then we have the pure common law trust. That's a private contractual trust created outside statutory incorporation, enforceable under equity and contract principles, which is quite similar to the business trust here. I think I should have read them in the order from left to right and then down, but that's just to get us started. Let's break it down now. What is a trust? Imagine a parent transfers their house into a trust. The bank, acting as a trustee, now holds the legal title, which means the bank manages the property, but doesn't own it for itself. So this is having a bank act as a trustee. The children, called beneficiaries, enjoy the benefits of the house, though they don't control the title. The parent, known as the settlor, also called a grantor or trustor, is the one who creates the trust by putting property into it. The simple story shows the heart of a trust, separating management from enjoyment. So, a trust separates legal title, which the trustee holds, and equitable enjoyment, which is for the beneficiary. The settler, or grantor, or trustor, creates the trust. How do we create the trust? Put property into the trust. Transfer property into the trust. The trustees then manage that property for others' benefit. So here's our key takeaway. A trust is a way to split ownership, legal and equitable here, so that one party manages property while another enjoys its benefits. Yes, indeed. Audit them, hit the like. as instructed. So let's go on to the creation and formalities of a trust. So a trust cannot exist by accident. The law requires clear intent from the settlor, an identifiable property or fund called the trust corpus or res, a lawful purpose, and definite beneficiaries, unless it is charitable where the beneficiaries are indefinite. Without these elements, courts will find no trust, only an enforceable wish, an unenforceable wish, or gift. Formalities also matter. Written instruments for real estate, clear declarations for personal property, and proper execution of deeds. These requirements give structure and certainty to the settlor's intent. The essential elements: intent, trust property, purpose, lawful purpose, and definite beneficiaries except charitable when they could be indefinite. Charitable trusts also allow indefinite beneficiaries, and formal requirements ensure the enforceability. That way you have something that's clear to hold up in court. So our key takeaway: a valid trust requires intent, property, purpose, and beneficiaries. Mere wishes or informal promises are not enough. Okay, we're on to the structural conflicts when roles merge. Now, here's a tricky part with trust, so this is an important part to pay attention. A trust exists only when the roles of settlor, trustee, and beneficiary are meaningfully separated. If the same person is both the sole trustee and the sole beneficiary, the trust collapses. Legal and equitable ownership merge into one, leaving nothing for equity to enforce. Similarly, if the settlor makes themselves the sole trustee and sole beneficiary, no trust is created. This separation of roles is essential to the very concept of a trust. So, the trust requires distinct roles: settlor, trustee, beneficiary. Merging roles eliminates trust structure. Equity requires separation to enforce the obligations. We'll get into more details about exceptions, as everything does have. So the key takeaway is a trust fails when the same individual occupies every essential role, because there is no true division between management and enjoyment. But there are permitted overlaps of roles. While some role conflicts destroy a trust, others are allowed. A settlor may name themselves trustee so long as there are other beneficiaries to receive the equitable interest. Likewise, a trustee may also be a beneficiary, provided they are not the only one. These overlaps are common in family trust, where a parent acts as both settlor and initial trustee, while children are the beneficiaries. The law tolerates such dual roles as long as the trust structure preserves the essential separation of management from enjoyment. So, the settlor can be the trustee with additional beneficiaries. The trustee may also be a beneficiary, but not the sole one. And dual roles are permitted if separation remains intact. So our key takeaway from this is the overlaps are permitted when they preserve the trust division of roles. A trustee can also be a beneficiary, but not the only one. Greetings, Craig Carey. Yes, you're welcome for pointing out the resources here. So let's continue here. Now we're on to the powers and discretion of trustees. Trustees are not passive custodians. They are empowered to invest funds, lease or sell property, and make discretionary decisions about distributions. These powers, however, are bounded by fiduciary duty and the terms of the trust. A trustee may have discretion to decide when and how to distribute income, but that discretion must be exercised reasonably not arbitrarily. Compared to simple gifts, the trustee's powers allow property to be actively managed for long-term preservation and growth. So trustees hold powers of investment, management, and distribution, but the discretion must be reasonable and not arbitrary. And the act of management distinguishes trusts from gifts. So you don't go there and maintain a gift once you give it to somebody, but in a trust, the trustee does. So the key takeaway, trustees wield active management powers that make trust dynamic tools, while fiduciary law ensures those powers are not abused. So now we're on to the fiduciary conflicts, and when there's a misuse of trustee power. Unslave us. Well, the first step is what we're going to see here as we go through this presentation, and it's not very long. You're going to see a way of keeping out of the slave system for some extent, because when you bring some of these essential roles into the private, then you're able to manage them yourself. You're not relying on others. Because remember, if you're letting others manage your affairs, then if you're not aware of their methods, then they become the king. Fiduciary conflicts, the misuse of trustee power. Even when roles are properly separated, a trustee must never exploit their position. Trust law strictly forbids self-dealing, such as selling trust property to themselves, borrowing from the trust, or diverting assets for personal use. Trustees must also avoid favoritism among beneficiaries, unless explicitly authorized. Yeah, the favorite son, you can give him a little extra. That could be in the trust. These rules ensure trustees act solely for the benefit of the trust, not for themselves. Breaches can lead to removal, restitution, or surcharge by the courts. So, even the courts can get involved in this. Trustees are prohibited from self-dealing. Favoritism is not allowed unless authorized. Breach leads to removal or restitution. So our key takeaway, trustees cannot use their powers for personal gain or unfair advantage. Fiduciary duty requires absolute loyalty to the beneficiaries. So we're on to the rights and remedies of beneficiaries if they've been wronged by this trustee here. Beneficiaries are not passive recipients. They have legal rights to demand accounting, inspect trust records, and compel trustees to act according to the terms. If trustees breach their duties, beneficiaries can seek judicial remedies, including removal, restitution, or surcharge. These remedies distinguish trust from informal family arrangements or business deals, where recourse may be limited. The trust relationship creates enforceable rights that protect the beneficiary's interest, so the trust becomes its own law. The beneficiaries can demand accounting and inspections. They can compel the trustees to perform duties, and the remedies include removal, restitution, and surcharge. So our key takeaway, beneficiaries are legally empowered to hold trustees accountable and enforce the trust's promise. And when you think about government, people that work in government is acting as trustees for the benefit of the people, that the people are the beneficiaries, and they're not supposed to be not supposed to be passive recipients because of legal rights to demand accountings, inspect records, and compel them, the trustees, to act. Gives it a different light. Of course, this comes back to fiduciary duties here, as we saw in the previous slide here. Somewhere in here. The print's too fine, I can't scan it that fast, but you can go back and rewind, indeed. The jurisdiction and court supervision. Trusts live under the supervision of courts of equity. And that's interesting there. While trustees are given broad powers, beneficiaries and the public rely on judicial oversight to enforce duties and prevent abuse. Charitable trusts in particular are supervised by courts or the Attorney General to ensure funds remain true to their mission. Equity's jurisdiction ensures that the trust system is not self-policing, but anchored in legal enforceability. Without this oversight, the equity jurisdiction, trust would collapse into mere promises. So equity courts supervise trust administration. Charitable trust receives special oversight because, of course, the beneficiaries are indefinite. And judicial enforcement ensures accountability. So the key takeaway, courts of equity ensure that trusts remain accountable, enforceable, and faithful to their purpose. Okay, let's move along here. This isn't too long of a presentation, but there's a lot of very important, dense information. I hope it answers all the questions you may have, but we're afraid to ask about trust. So, inheritance without probate. When someone dies owning property in their name, probate court must oversee the transfer to heirs. This process can take months or years, cost significant fees, and expose private family affairs to public record. A living trust avoids this entirely. The parent, as settlor, places the property into the trust during life, and when they pass, the successor trustee, the person named to take over when the original trustee cannot serve, continues managing it seamlessly. The children receive property without delay or court oversight. Compared to a will and probate, the trust provides privacy, efficiency, and continuity. So, probate is slow, costly, and public. A living trust avoids probate delays, and the successor trustee provides continuity. So our key takeaway, a trust is the superior alternative to probate, ensuring smooth, private, and cost-effective inheritance. But by no means is this supposed to be legal advice for any kind of wills or estate planning, etc. This is strictly for the educational entertainment purposes of this YouTube channel. Let's continue. Now there's protecting a spendthrift heir. Oh boy, spendthrift heir. If an heir with poor money habits, the spendthrift, receives property outright, they may squander it, or creditors may seize it. A trust overcomes this risk through a spendthrift clause, which locks the property so it cannot be sold, pledged, or attached by creditors. The trustee manages distributions carefully, ensuring the heir is supported without wasting the inheritance. Ordinary transfers of property expose assets to loss. A trust ensures long-term protection while still fulfilling the settler's desire to provide for the heir. So the spendthrift clause, if there is one in the trust, it prevents the creditor claims and reckless spending. So it protects the property from creditor claims and from the spendthrift heir and reckless spending by the spendthrift heir. The trustee controls distributions in order to protect the inheritance. Outright gifts lack these protections. Key takeaway, a trust uniquely shields assets from both the heir's mismanagement and outside creditors, which direct gifts cannot. All right, let's move on now from the family to the business. Craig Carey says everything is upside down and backwards these days. Good thing that it is football season. We just don't know. Yeah, exactly. All right, so let's get to our corporate style trusts. In fact, I believe the NFL until just recently was a PMA, a member association. It wasn't a corporation. But I digress. So corporate style business trust. Business partners typically form corporations or partnerships to run enterprises, as we learned from the previous live stream that the corporations and the partnerships were to distribute profits between the partners And the corporations, of course, are the way to have the business run, where it's organized as that particular personal entity that has limited liability for the partners or the people running it. So these are different ways of running the enterprises in a corporate style. These structures require statutory filings, compliance obligations, and often limit flexibility. Again, you got to see that the NFL wasn't this way until just recently, and that was for some other complex issues. Nevertheless, corporations and partnerships aren't the only way to engage in this type of corporation style. A business trust offers a different path. The investors transfer property into the trust. Trustees manage operations like directors, and beneficiaries receive income like shareholders. Unlike corporations, the business trust is grounded in private agreement, offering flexibility, privacy, and simpler governance. It achieves the same goals of pooling capital and limiting liability, but through the adaptable framework of trust law instead of through corporate and legal structures. The business trust functions like a corporation, but under trust law. The trustees manage the operations. The beneficiaries receive income. It provides flexibility, privacy, and simpler governance. So our key takeaway, a trust can serve as a streamlined alternative to corporate entities, combining protection, privacy, and profit sharing, as in a partnership. So you see the advantages of structuring it within the framework of trust law, because it's, first of all, more adaptable than corporate law, and it includes privacy and other flexibility and simpler governance. You don't have the same filings required by state entities, corporations. So we're on to charitable trust for education. Donors who give money directly to schools or individuals may see funds misused, diverted, or exhausted quickly. A charitable trust ensures that the property is held and managed for the specified purpose, such as scholarships, with trustees bound to the mission, and courts or public officials overseeing compliance. So you see this a lot with some alumni associations where they will have scholarship funds that are managed by a trust, and these could be very old, long-time trusts, and as different alumni members serve as trustees, the trustees are compensated for their role too. And the pooling of this money for use of scholarships has to be done properly with their fiduciary duty of the trustees, and then they're rewarded for that with whatever compensation they get for managing those funds. Unlike one-time gifts, the trust can continue indefinitely, as some have for a very long time, steadily supporting education or other charitable causes, according to the donor's vision. It provides permanence, accountability, and structure to charitable giving. So it direct gifts risk misuse or exhaustion. So directly giving, they could just use it all up and it's gone. It's like, well, what happened to it? But the charitable trusts provide permanence and oversight to make sure that is managed well. And trustees and courts enforce the donor's vision. So you know that there's a little bit of bite to the whole express purpose of the charitable organization, knowing that the courts can enforce the purpose of your donations. So the key takeaway, a trust transforms private generosity into enduring public benefit with oversight and continuity unmatched by direct donations. All right, which takes us to private family contractual trust. So families who wish to manage their assets privately may resist incorporation or statutory oversight. If they rely on contracts between themselves, disputes may lack clarity or enforceability. Yeah, your Uncle Bob, he might not pay back. So by forming a pure common law trust, the family creates a binding, private agreement called a trust indenture or trust instrument. This written document lays out the rules for how trustees manage the property and how beneficiaries benefit from it. Because it is based on contract and equity rather than state registration, the trust operates independently of corporate law, yet courts will still enforce its terms. Unlike statutory entities, this trust is rooted in private autonomy, ensuring both flexibility and enforceability. So families may avoid corporate registration by using a trust, a private family contractual trust. The trust indenture sets enforceable private rules. And equity ensures enforceability without statutory filing. So the key takeaway, a trust gives families a legally enforceable way to govern assets privately, achieving both autonomy and stability. All right. Johnny D loves this broadcast. Good job. Well, thank you. And we're not over yet. We're getting to the good stuff right now. If you've made it this far, it'll be worth the wait. So, acquisition of property by a trust. A trust can acquire new property just as any legal owner might, by purchase, gift, or exchange. The difference is that the property acquired becomes part of the trust corpus, also called the trust res, under the trustee's control and subject to fiduciary duties. Unlike individuals who may buy property but later mismanage or lose it, the trust ensures that all acquisitions are managed consistently under its governing instrument. This provides continuity, accountability, and protection from personal liabilities that would otherwise attach to an individual owner. So look at all the advantages here. The trust can acquire property by the same way anyone else would: purchase, gift, or exchange. The acquired property becomes part of the trust corpus or the trust res, and the property is managed consistently under the fiduciary duties of the trustee. The key takeaway: when a trust acquires property, that property is governed by the trust rules, the law of the trust, and protected for its beneficiaries, unlike ordinary ownership. So, very powerful governing rules that are part of the trust that protect the beneficiaries, unlike ordinary ownership would. So we're on to the retention and preservation of property. Very important aspect. Ordinary ownership exposes property to personal debts, disputes, or poor decisions. A trust allows property to be retained securely for long-term purposes. Trustees are required to manage and preserve the property, balancing investment, risk, and loyalty to the beneficiaries. The absolute loyalty. This means assets are less likely to be dissipated or diverted. For families, retention ensures wealth survives generations. For businesses, it ensures continuity. For charities, it ensures funds remain dedicated to the mission. So, the retention and preservation of properties, credible aspects of trust. The trustees must preserve the property for long-term purposes. Protection from mismanagement and outside claims, and ensures continuity for families, businesses, and charities. So our key takeaway: trusts provide a stable vessel for property retention, protecting it against loss, mismanagement, and outside claims. Okay, we're on to constructive and resulting trust. Not all trusts begin with a settler's plan. Courts may impose trusts to prevent injustice. A constructive trust is declared when someone wrongfully holds property, compelling them to act as trustee for the rightful owner. A resulting trust arises when property is transferred in circumstances suggesting the recipient was never meant to keep it outright. These judicial trusts ensure equity prevails, even when no formal instrument exists. They show how trust law serves both planned arrangements and remedial justice. So constructive trusts prevent unjust enrichment. Resulting trusts arise when intent is unclear or implied, and courts impose these to ensure fairness. So our key takeaway from this: courts may impose trusts by equity to prevent unjust enrichment and ensure property is held for its rightful purpose. We've seen lots of incidents where the property is held in trust, and the trust is created by the court, and they assign a trustee. Common pitfalls in creating trusts. Trusts only work as intended when they are carefully created. Many fail at the outset because the settler's intent is unclear or not properly documented. Without clear language, courts may refuse to enforce the trust. Thus, it would lose its enforceability. Others falter because the property was never actually transferred into the trust, leaving nothing for the trustee to administer. Some trust instruments try to do too much, creating contradictions or illegal provisions that courts strike down. These missteps often undo the very protections a trust was meant to secure. So some of these pitfalls: unclear settler intent leads to invalid trusts. Property must actually be transferred into the trust. Overcomplicated or unlawful provisions cause failure. So again, the intent has to be a purpose, lawful purpose. So our key takeaway: the foundation of a trust, a valid trust, is clear intent, proper transfer of property, and lawful, consistent terms. Oh boy, here you get missteps in trustee selection. Even the best drafted trust fails if the wrong trustee is chosen. Trustees must act with loyalty, prudence, and impartiality. Selecting an unqualified, careless, or conflicted trustee often leads to disputes, financial loss, or litigation. Family members may be trusted emotionally, but lack the skill to manage complex assets. Professionals may bring expertise, but can be expensive or disconnected from family needs. A trust's success depends heavily on balancing these considerations in selecting the right trustee. So the trustee choice is critical to trust success. Unqualified or conflicted trustees create disputes. And you need a balance of family familiarity and professional skill when you're selecting a trustee. So our key takeaway: choosing the wrong trustee undermines the trust's mission. Trustee selection is as critical as the trust's terms. Wow. So the best constructed trust could fail without a good trustee. Oh boy. Now we get to the over-reliance on boilerplate forms. Many trusts are drafted using generic templates or borrowed forms that do not fit the settler's specific goals. This often results in provisions that conflict with state law, fail to anticipate real-world contingencies, or omit critical powers for the trustee. Courts may fill in gaps or strike down provisions, but the outcome may not reflect what the settler wanted. A trust must be tailored to its circumstances, not copied blindly. So boilerplate trusts often fail to match the specific goals. The risk of conflicting with state law or leaving gaps, and the courts may alter the outcome in unintended ways. So our key takeaway: a trust should be customized to the settler's situation. Boilerplate language invites failure. J&G says, this knowledge is more than I ever received at Smooth Operational Law and paid so much for that course. It was a waste. Thank you for your class and knowledge. Well, you're very welcome. And again, this is a compilation of many series I've done on trust here on this channel. And I see that it is such a complex topic. I figure it's something that I needed to do to really bring it together in a way we could get through this smoothly and see it in a practical applications. So, ignoring tax and creditor consequences. Some trusts are created without considering tax law or creditor claims. A poorly structured trust may inadvertently increase estate or income taxes, expose assets to creditors, or fail to qualify for intended protections. Wow. So you got to be considerate of those tax laws and creditor claims. For example, omitting a spendthrift clause leaves assets vulnerable, while careless drafting of charitable trusts may disqualify them from tax benefits. The promise of asset protection or tax efficiency can vanish if these issues are ignored. So poor drafting can trigger tax liabilities. These are things you would always check your trust against, and it's easy to do. You just review them in this context through the tax law and in creditor claims. Assets may remain exposed without protective clauses. Was there a spendthrift clause? If so, is it adequate? And charitable benefits may be lost without compliance. So, is there a record keeping that needs to be established to validate the charitable status of the trust, and thus be qualified for tax exemptions? The key takeaway: trusts achieve protection only when carefully aligned with tax and creditor law. Neglecting this risks costly surprises. Indeed. This takes us to the termination and modification of trust. Let's jump over here. Yes, Raymond Delon and Queen of Dominion of We Are Lost. Many people, I'm so appreciative of your time. This community needs more people. Well, thank you, and I appreciate you, and definitely get the word out so we get more subscribers here. And this is what it's all about: is to share this information in a way that it could be useful to everybody to gain the benefits of what these mechanisms and structures were put in place for in the first place. We don't all have to go running to some state-created entity to solve our problems when there's plenty of private solutions available to us and have been for a very long time. All right, let's continue. The termination and modification of trust. So trusts are not necessarily permanent, and typically they're not designed to be. A trust may terminate when its purposes are fulfilled, or become impossible when the settlor and all beneficiaries agree, or by court order. In charitable trust, the si pre doctrine allows modification when the original purpose fails. And I think that was last night's live stream, the si pre doctrine is close as possible, or as near as possible to the original intent. So if whatever process was set up for the charitable trust to, I don't know, invest or whatever, if that's not available anymore, they have to come with something as close to it as possible to achieve that original intent of the settlor. So the si pre doctrine is what that is. And in charitable trusts, the si pre doctrine allows modification when the original purpose fails, redirecting the trust to a similar purpose. Of course, the similar purpose being with the same intent of the original settlor. Knowing that trusts can end or adapt is vital, as it ensures the flexibility without undermining their stability. So trusts end when purposes are met or impossible, or settlors and beneficiaries can agree to terminate. Now, the modifications that charitable trusts adapt under the si pre doctrine. So as time goes on, they have to meet their goals. If that means that they're supposed to see by the trust a certain rate of returns from their investment, and what was originally used to achieve that is no longer available, they could adapt under the si pre doctrine to find a comparable alternative that would meet that similar purpose of, so as in our example, achieving a certain rate of return for the trust. So, key takeaway: trust can end or be modified to meet changing circumstances, ensuring the settlor's intent is honored as closely as possible. Okay, one framework, countless applications. So whether preventing probate delays, protecting heirs, acquiring and retaining property, organizing businesses, ensuring accountability, funding charities, or preserving family autonomy, each story highlights the same underlying framework. The settlor creates the trust. The trustee manages it under fiduciary duties, and the beneficiaries enjoy the results. Ordinary transfers, contracts, or business structures often leave gaps in protection, continuity, or accountability. Trusts close those gaps, applying one framework to countless real-world needs. The same framework solves diverse problems. Trusts succeed where contracts or gifts fail, and trusts combine protection, continuity, and accountability. So our key takeaway, trusts provide a single, adaptable structure that solves diverse problems more effectively than typical alternatives. Which will bring us to our conclusion. So over here, the chat. And J&G requests that everyone like and subscribe. You don't need people like these guys. And we are okay, I get it. Yes, indeed. Well, thank you very much for the kind words, and definitely would take that advice. And yes, there's a whole playlist of American jurisprudence videos. I think we're getting close to 100 somewhere in there. But there's quite a few in there on trust too. And this is actually a compilation of the American jurisprudence on trust. I think over 400 sections, most covered already on this channel. And also the express trust and common law, pure business trust, a whole bunch of resources there compiled into this. And indeed, well, everyone is welcome. So we're a tribe of ideas. So let's get to our conclusion here, why people create trusts. People create trust because they achieve what ordinary tools cannot. They preserve family wealth while protecting heirs from creditors or themselves. They avoid probate and maintain privacy. They acquire and retain property in a stable, accountable structure. They organize businesses without cumbersome statutory regimens. They enforce accountability in management where contracts might fail. They transform charitable giving into lasting institutions. And they allow families to govern themselves privately while still having legal enforceability. In every case, the trust balances control with protection, making it the ideal legal instrument for enduring results. Trusts preserve wealth and protect heirs. Trusts provide privacy and avoid probate. And trusts enable businesses, charity, and family governance. So our key takeaway, trusts endure because they solve problems no other structure can, combining flexibility, protection, and enforceability. All right. Indeed. So I would like to thank you all for attending Trust Explained, the principles, pitfalls, and practical applications. I hope it illuminated a lot of the aspects of the general applications of trust where a lot of the pitfalls come in, things to avoid like boilerplate trust, and to ensure you understand the underlying principles, which once those are understood, you see that the trust is actually a lot simpler than some of the other structures used to deal with business. So, indeed. Yes, everyone, please be a member of the tribe. What I was thinking about for the membership is also to make downloadable presentations available for everyone if they want to go over these on their own or even share them. That I was thinking about doing that for the membership, but I'd have to figure out how to set that up. But if I get enough feedback on that, then that's something I would definitely consider. Well, with that being said, again, I'd like to thank you all and salute you for spending the time here to learn more about trust and ways we can apply these to our own lives, our own families, and our own businesses, and to ensure that this type of structure here is used for the benefit of those it was made for, us, the people, and in the private. With that said, a salute to you all, and I hope to see you all on the next one. Peace out.